Hello, my name is Subin and I am here to teach you something about environmental law. Environmental law requires an in-depth analysis. There's been a huge change in the way it has been tackled. Now, the biggest challenge for law is to keep up with scientific and technological advancements. Now, what we would be looking into in this module is we'll have an introduction about the subject. We'll talk about the right to environment. We'll deal with the principles of environmental governance, and then we move on to the important pollution control laws in India. We'll also be looking into laws relating to environment, forests, wildlife and biodiversity in India, and we'll also look into the international developments as well. And we conclude with the future of environment. We'll examine the subject in a rights versus duties aspect and figure out the ways and methods in which it grew in importance in the first place. By tracing the history of environmental law, we'll try to put across various developmental stages that the law went through before reaching its present stage. Now, environmental protection is one of the most important areas insofar as the future of mankind is concerned. The fruits that we receive from the environment helps ensure that life exists while enjoying all the benefits. Therefore, it's absolutely necessary that the same be protected and preserved. Understanding the real nature of protection that need be afforded to the earth is one of the biggest challenges. Now, Justice Chinnappa Reddy, he had reproduced the wise Indian chief of Seattle saying about nature in Sachidananda Pandey and Another versus the state of West Bengal and Another. It assumes significance. To the offer from the great white chief of Washington to buy their land, the Indian chief responded thus: "How can you buy or sell the sky, the warmth of the land? The idea is strange to us. If we do not own the freshness of the air and the sparkle of the water, how can you buy them?" This conveys the true spirit with which some people treat the environment and Mother Nature. Now, this relationship with nature is something that has grown through the ages. It's not something that has occurred within a short span of time. Rather, it has come to the forefront in a slow and steady manner. The importance of environmental protection is understood from the fact that the closeness that one feels towards the environment is something that comes from within and cannot be shaped otherwise. Ensuring that the environment is protected for future generations as well is one of the most important thoughts as far as environmental protection is concerned. It has to be understood that nature and its resources are not there solely for the fulfillment of human needs and wants, but they too do have certain rights of their own. Unfortunately, these rights are not protected in the same way rights of humans are. Rights and duties, they form an important part of law. This is so because the existence of these concepts help create a legal system which functions smoothly and efficiently. The state was treated as a provider of rights, and the governed surrendered their rights to the state in exchange of protection being afforded by the state. Duties, on the other hand, form the opposite side of rights and are the correlatives of rights. The existence of both these concepts does create a system wherein a systematic balance is sought. Law does command or forbid doing certain acts. Such actions may form the rationale behind the duty and is treated as the subject matter of duty. Now, it clearly lays down that if one has to perform a duty, irrespective of the fact as to whether one likes it or not, he has to do it because it's his duty. Thus, rights correspond to certain duties which need be fulfilled, and that are exactly why they are termed as correlative. Now, a healthy relationship between these two concepts ensures some kind of a balance in society. This mutually symbiotic relationship helps the society grow and achieve its objectives. The question that might arise is as to whether there is a need to protect the environment. Now, it's quite clear that humans, though they have made scientific advancements, still have not been able to unravel all the mysteries of the world. This creates a situation wherein the need to protect the environment arises. Man, it is felt, still depends quite a lot on what is being provided for by nature. This, in turn, creates a situation wherein he is to protect nature. This might be for a survival, but it does ensure protection of the environment. Overexploitation of resources led to a scarcity of resources, and this also increased the importance of protecting the environment. This was one of the catalysts as far as protecting the environment is concerned, and necessitated that a duty be imposed on humans. Environmental law can be said to originate from the common law concept of nuisance. Divided into two, public as well as private, this concept has developed over the ages. The former deals with the interference with use of land, and the latter deals with the interference with the common right of the general public. Easement rights guarantee owners to enjoy land free from pollution, and in case there is some, the owner could challenge the act of pollution as amounting to public nuisance. When the harms of such an extent that the general public is affected, it becomes a public nuisance. In Perumal Nayaka versus Ratna Nayakar, a 2004 decision by the Madras High Court, the court opined that public nuisance is a combination of both civil as well as criminal characteristics, and thus it warranted both civil as well as criminal prosecution. Now, the Indian Penal Code, section 268, makes it punishable. Apart from this, negligent acts which are dangerous to life, sections 269 and 270 of the IPC. Adulteration of food, drinks and drugs, sections 272 to 276 of the IPC. Contaminating water of public springs or reservoirs, section 277 of the IPC. Polluting the atmosphere, section 278, are all treated as punishable offences. Section 133 of the Code of Criminal Procedure, it states that an executive magistrate can interfere and remove a public nuisance in the first instance with a conditional order and then a permanent order. Such orders can be used in case the nuisance so caused is related to environmental harm. As Section 133 was used by the judiciary in India to ensure environmental protection. The Ratnam Municipal Council versus Vardhachand case is a landmark decision which increased the role of the judiciary and laid down principles of judicial activism in India. Now, the residents of the municipality were suffering from a pungent smell arising from drains and slums. The municipality did not follow the order of the magistrate to remove the drain and construct toilets. Instead, the municipality challenged the said order. Now, the matter, it reached the highest court, and it was laid down by the Supreme Court that local bodies were responsible to protect the environment and take necessary steps. Justice V.R. Krishna, in this case, took a stand that the law takes a mandatory stand and it's the duty of the local administration to ensure environmental protection. The process initiated under Section 133 thereby has a social justice component, and the courts opine that there should be no hesitation on its part to provide all that is necessary to augur environmental protection. Another method that has been used is to ensure that there are civil remedies which have been raised for environmental hazards. The law mandates that any person who has been affected by any harm caused to the environment is entitled for remedies for the infringement of his civil rights. In State of Andhra Pradesh versus M.V. Naidu, a 1999 Supreme Court decision, the court developed the law on public nuisance and set it to have a persuasive value while deciding litigation. Now, what is this right of environment or the right to environment that you are talking about? Now, environment is a term which has been used for long and owes its origin to the French term environ, meaning surrounding. Life depends on the environment in which we live in. This makes it all the more important that a safe, clean and healthy environment is present, apart from it being sustainable as well. The participation of the people in decision making goes a long way, and this is true in the case of environment as well. And in recent years, one cannot help but notice the link between environment and human rights, and the same has increased drastically. Given this importance, it was quite imperative that such a right be included in various laws and constitutions of countries around the world. It can be argued that environment destruction violates human rights. This interrelationship conveys the idea that once the environment rights protection suffer, simultaneously human rights too will suffer. All rights attached to a human can be enjoyed to maximum only when one lives in a safe, healthy and sound environment. The right to a healthy environment is recognized by international as well as regional conventions. Article 12(2)(b) of the ICESCR requires state parties to improve all aspects of environmental and industrial hygiene. Article 11 of the Protocol of San Salvador to the American Convention on Human Rights recognizes the right to a healthy environment, and Article 24 of the African Charter on Human and People's Rights states that all people shall have the right to a general, satisfactory environment favorable to their development. CESR General Comment number 14 talks about the right to the highest attainable standard of health, laid down in Article 12. It mandates health is a fundamental human right, indispensable for the exercise of other human rights. What is noticeable in this is that Article 12(2) acknowledges that right to health is dependent on a healthy environment as well. Now we talk about environment. We do also have to look into India. Now from an Indian perspective, you also did have ancient Indian environmental ethics in place. India, as a matter of fact, did have a long-standing connection with protecting the environment, which was evident from the early Vedic times itself. The main motto was to live in harmony with nature. A sacred duty was cast on each and every person to protect and revere nature. Hinduism, being more of a way of life than a religion, through its 4 Vedas, it portrayed many aspects of environmental protection. The Smritis as well as the Upanishads also did convey similar ideas. Now the Indian constitution also has the right to live in a healthy environment, albeit not directly. In the original constitution, there weren't any specific provisions related to the environment. It was in the 1972 Stockholm Conference. Our Prime Minister back then, Mrs. Indira Gandhi, she addressed the gathering and spoke about the need to protect the environment. She pointed out and raised concerns about eco-imbalance and stressed upon the fact that pollution, population and poverty need be tackled as one. And India soon passed the 42nd Constitutional Amendment Act in 1976, as a result of which 2 articles, Article 48A and Article 51AG, were added to the Constitution. The former is a part of the directive principles of state policy, while the latter is a fundamental duty imposed on Indian citizens. It ensures betterment and propounds the concepts and framework related to protecting the environment. Though one might notice that the words used are different, it does convey a similar idea. It was opined by the court that fundamental duty and the directive principle of state policy should be given effect in all cases. Justice R.N. Mishra opined that environment preservation is not only the duty of the state but also of the citizen. In Sachidananda Pandey versus State of West Bengal, the Supreme Court opined that the court should bear in mind Articles 48A and 51AG in all matters related to environment. In S.K. Kulwal versus State of Rajasthan, the Rajasthan High Court held that Article 51A's rationale was that right and duty coexist. There cannot be any right without any duty, and simultaneously there cannot be any duty without any right as well. The 7th schedule, which contained various lists based on who has the power to legislate, was also changed. Now, since governmental power in India is divided between the union on one side and the state governments on the other. There are 3 lists in the 7th schedule which contain subjects on which respective governments can legislate. Overlaps and shared jurisdictions as regards some areas like forests, wildlife, mines and mineral developments, they are not covered in the union list and is present in list 3, which is the concurrent list. Now, the Parliament can also enact laws on state subjects by virtue of Article 252 for states whose legislatures have consented to central legislation. Now, there were quite a number of international steps which were taken to promote environmental protection as well. India too was a party to many a step. Once such a step is taken, it is quite imperative that steps are taken to include such commitments and obligations into domestic law. Article 51C of the Constitution states that the state shall endeavour to foster respect for international law and treaty obligations in the dealings of organized people with one another. In light of such commitments that India entered into internationally, the same was to be read as part of Indian national law. By virtue of Article 253, the Constitution specifically empowers the Parliament to make any law for the whole or any part of the territory of India for implementing any treaty, agreement or convention with any other country or countries or any decision made at any international conference, association or other body. The Supreme Court of India in PUCL versus the Union of India, a decision rendered in 1997, held that international covenants to which India is a part of can be read into Indian law. They are in addition to the rights that are present and can also be made enforceable. In Vellore Citizens Welfare Forum versus the Union of India, a 1996 Supreme Court decision, the court held customary international law rules which are in line with domestic law can be relied on by Indian courts. The Supreme Court of India also observed that the state has the responsibility to improve public health and protect and improve the environment, which was held in MC Mehta versus the Union of India, a 2002 decision. Apart from all these instances, the main change that was brought about was the change in the attitude of the courts. Now this led to an expansion of the right mentioned under Article 21. While it mentioned that no person shall be deprived of his life or personal liberty except according to the procedure established by law, it is treated as a basic human right. Judicial intervention, case laws and interpretations have transformed these into positive rights. The Supreme Court in Menaka Gandhi versus the Union of India revolutionized the perception of personal liberty and said that law which affects the life and liberty of a person should be in tune with Articles 14 and 19 of the Constitution. That is, the law related to the life and liberty of a person, if it restrains such rights, should mandatorily require that the procedure established by it to that effect is reasonable, fair and just. This brought in a new era, as before this, fundamental rights were thought to impose only negative obligations. This was the first instance wherein the Supreme Court changed a right into a positive right and cast a positive duty on the state to enforce it. Now, this was reiterated by Justice Bhagwati in Francis Corelli case, wherein he held that the right to life enshrined in Article 21 cannot be restricted to a mere animal existence. It means something more than just physical survival. In Chameli Singh versus the state of UP, the Supreme Court of India opined that the need for a decent and civilized life includes the right to food, water and a decent environment. Now, this was said to be one of the most ingenious phases of the Supreme Court of India and has been identified so by Professor Armin Rosenkrantz and senior advocate Shyam Diwan. In RLEK versus the state of UP, a group of people wrote a letter to the Supreme Court and put across and stated that mining activities were destroying hills. Now, this letter was treated as a writ petition, and the Supreme Court appointed an expert committee to advise the bench on technical issues. And based on this report that was submitted by the expert committee, the court directed that the quarries be closed. In the oleum gas leakage case, the Supreme Court reiterated that the right to live in a pollution-free environment is a part of Article 21. In the tanneries case, wherein Ganga was being polluted, it was held that the closure of the tanneries may bring unemployment, loss of revenue, but life, health and ecology have a greater importance to the people. In L.K. Koolwal versus the state of Rajasthan, health, sanitation and environment were held to fall under Article 21 of the Constitution. In Subhash Kumar versus the state of Bihar, the Supreme Court observed right to live is a fundamental right under Article 21 of the Constitution, and it includes the right of enjoyment of pollution-free water and air for a full enjoyment of life. In Virendra Gaur versus state of Haryana, the Supreme Court opined hygienic environment is an integral facet of right to healthy life, and it would be impossible to live with human dignity without a human and healthy environment. In Dr. Ashok versus Union of India, the Supreme Court gave an extended meaning to the expression of life in Article 21 of the Constitution and brought health hazards caused as a result of pollution within it, and so also the health hazards from use of harmful drugs. In Banvasi Seva Ashram versus state of UP, forest dwellers who used forests as their habitat and means of livelihood were put in trouble when part of their land was declared as a reserved forest. Now, the rest of their land was sought to be acquired to a thermal power plant. Now, the Supreme Court directed that safeguards were to be made and the interests of the Adivasis and backward people who were being ousted from their forest land by NTPC should be protected. The court permitted the acquisition of land only after NTPC agreed to provide certain facilities to the ousted forest dwellers. In Pradeep Kishan versus Union of India, the Supreme Court held that there is a need to protect the right of livelihood of the tribal on the one hand and ensure protection of the ecology on the other hand. In Bangalore Medical Trust versus Mudappa, steps were taken to convert a public park into a hospital. When the matter reached the Supreme Court, the court was of the opinion that public parks are important and highlighted its importance. Now, there are quite a large number of principles related to environmental governance. Governance of the environment is one of the most important concepts as far as environmental law is concerned. Having roots and bases in political ecology as well as policy, environmental governance assumes significance. There are quite a lot of activities that need to be balanced. Social, cultural, economic, as well as political aspects of governance need to be kept in mind while chalking out a plan of environmental governance. Sustainable development is something that need to be understood. Our Common Future, published in 1987 by Dr. Gro Harlem Brundtland, the then Prime Minister of Norway, defined as to what the concept of sustainable development is. Sustainable development is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. Based on the Rio Declaration of 1992, this concept of sustainable development does bring within its ambit quite a lot of other things as well. It constitutes 4 elements: prudent and rational use of natural resources, intergenerational equity, intragenerational equity, and the principle of integration elements. The whole idea behind the concept is to ensure that resources are protected for the future generations. Now, it mandates that conservation need be seen as an essential component of planning and execution of developmental actions. The definition itself puts across the idea of needs and limits. It can be said that the objectives of the principle is met only when the needs of both the present as well as future generations are met. It is also to be kept in mind that there are certain limits which have been proposed so that the environment is not under much strain. The second principle is the precautionary principle. Anticipating harm that would be caused to the environment and taking steps to avoid it is the core idea behind this principle. The importance of this principle is that it should be followed in cases of imminent danger as well as situations which pose a risk. The rationale behind this is laid down in Principle 15 of the Rio Declaration. The precautionary principle plays a great role in finding out the sustainability of a process, and most importantly, it aims at minimal harm. The precautionary principle confirms that a substance or activity which poses a risk to the environment is prevented from harmfully affecting the environment, even in the absence of any conclusive scientific proof to that effect. The Supreme Court of India recognized this principle in the Vellore case. In the context of municipal law, the precautionary principle means environmental measures to anticipate, prevent, and attack the causes of environmental degradation. 2. Lack of scientific inquiry should not be used to postpone measures for prevention of environmental degradation. 3. The onus of proof is on the actor, developer, or industrialist to show that his actions are environmentally benign. In Narmada Bachao Andolan case, this principle was used to formulate a new principle for the burden of proof, wherein the burden was placed on those who wanted to change the status quo as regards the absence of injury to the environment. Thus, a reverse onus principle was used to ensure that the proponent of the project should have the onus to prove that the technology and the methods are safe. The next one is the polluter pays principle. Now, this principle determines the punitive costs of damages which arise as a result of violations done to the environment. It tackles environmental protection and also public health damage that is caused by ensuring that the defaulting company or the person is held liable for actions and they have to pay for it. The effectiveness of this principle lies in the fact as to how severe the punishment is, which in turn ensures deterrence. Externalization of costs is prevented, and there is also a proper allocation of rights and obligations. Principle 16 of the Rio Declaration lays down this principle. The principle has been put into effect in Indian Council for Enviro Legal Action versus the Union of India. In this case, chemical factories in Bichri, without clearance, had produced hazardous chemicals. This percolated into water resources. The Supreme Court of India imbibed the polluter pays principle in this particular case. The next principle is the permanent sovereignty over natural resources. The right has been provided to the states to put to use the natural resources, but a corresponding duty also exists so as to ensure that the actions should not harm the environment. Principle 21 of the Stockholm Declaration puts across the same. Another principle is the principle of preventive action. Now, this principle requires that damage caused to the environment should be prevented. A state may be under an obligation to prevent damage to the environment within its own jurisdiction, including by means of appropriate regulatory, administrative, and other measures. According to this principle, action need be taken early, and if it is so possible, before the actual damage has occurred. Another one is the good neighborliness principle. The principle states and obligates nations to try to reconcile their interests with the interests of neighboring states. This, along with the principle of international cooperation, has helped in creating a better system. You also do have the public trust doctrine. Now, this is a principle which conveys that natural resources are held in trust by the sovereign on behalf of its citizens. Thus, they are to be treated as public and no one can assume control or claim a right over such resources. Emperor Justinian, he held long time back that the sea, the shores of the sea, the air and running water was common to all in his codified work, Corpus Juris Civilis. Now the importance of this principle can be understood from the observation of the US Supreme Court in the Monole case way back in 1983, wherein it laid down that the public trust is more than an affirmation of state power to use public property for public purposes. It is an affirmation of the duty of the state to protect the people's common heritage. In J.H. Wadia versus the Board of Trustees, Board of Mumbai, the Supreme Court of India held that states' actions and actions of its agencies, instrumentalities, all should be in public good. Professor Joseph Sachs, he opined that the public trust doctrine can be used by any citizen to fight exploitation of resources that should rightfully be protected common property. Now, according to him, public trust doctrine casts a duty on the government to protect the resources for general public use, and it should not be to foster private ownership or use for commercial purposes. Professor William Eraser, he summarizes criticisms of public trust doctrine as backward-looking, anti-democratic vestige whose time, if it ever existed, has passed. Now, this has been laid down in the Stockholm Declaration of 1972 as Principle 1. Article 24 of the African Charter on Human Rights and People's Rights guarantee that all people shall have a right to a general, satisfactory environment favorable to their development. Similarly, Article 11 of the Additional Protocol to the American Convention on Human Rights affirms that everyone shall have a right to live in a healthy environment and have access to basic public services. It also mandates that state parties shall promote the protection, preservation and improvement of the environment. In the International Court of Justice case, Gabčíkovo-Nekimiro's project, the Hungary versus Slovakia decision in 1997, Justice Veeramantri, he opined, the protection of the environment is likewise a vital part of contemporary human rights doctrine, for it is sine qua non for numerous human rights, such as the right to health and the right to life itself. You also do have the Aarhus Convention for access to information, public participation in decision making, and access to justice in environmental matters. It, in its preamble, also states that every person has a right to live in an environment adequate to his or her health and well-being, and the duty, both individually and in association with others, to protect and improve the environment for the benefit of present and future generations. In RLEK versus State of UP, it is held while bringing illegal mining to a stop that this is the price that has to be paid for protecting and safeguarding the rights of the people to live in a healthy environment with minimum disturbance of ecological balance. In MC Mehta versus Kamal Nath, Justice Kuldeep Singh used the term for the first time in India. Public trust doctrine ensures that the government has a duty to ensure environmental protection and is to act as some sort of a public trustee. They hold it in trust and the people are sovereign. In MI Builders versus Radheshyam, the question was whether a public park or a shopping complex should be constructed. The Supreme Court opined that to allow the construction would mean that citizens would be deprived of the quality of life to which they are entitled under the law. The government authority was obliged to manage this park for public good. In Reliance Natural Resources versus Reliance Industries Limited, a 2010 decision of the Supreme Court, it was held that the constitutional mandate is that natural resources belong to the people in this country. The 2G spectrum case laid down that natural resources are public good, and hence the doctrine of equality, which arises from justice and fairness, should guide the state. You also did have quite a large number of references of this doctrine by US courts as well. In National Audubon Society versus the Superior Court, famously known as the Mono Lake case, the US court confirmed the crux of the public trust doctrine. But what happened in this case was water was diverted by the state that would have otherwise flown into the Mono Lake, and this caused extreme ecological degradation. The court held that water rights may be truncated if protection of the resource demands so. In 1971, the state of Pennsylvania added the public trust doctrine in their state constitution. Article 1, section 27 speaks so. The public trust doctrine states that nature's gifts intrinsically belong to all. As a result of this, the government should try to bring about some sort of a balance between private use on one hand and public resources on the other, and avert the tragedy of the commons as has been laid down by Garrett Hardin. Another principle that we are supposed to look into is the principle of common but differentiated responsibility. Now, this has its roots in the principle of equity. Recognition of the special needs of developing nations are considered as far as development, application, and interpretation of rules of international economy. Principle 7 of the Rio Declaration states the same. Though sovereignty of each and every state remains equal, they assume differentiated responsibility in addressing environmental issues. Each country has a duty and a responsibility to protect and preserve natural resources. Now, based on their economic conditions and capabilities, the country's steps, capability might vary. We also do have to conduct some sort of an overview of important pollution control laws in India. Now, the Water Act is one of the earliest steps to that effect. After the Stockholm Conference of 1972, India took steps to enact this law to conserve and preserve water. Adopting a command and control formula, this act ensured better water protection. The command is stipulation of certain upper limits of parameters based on public health standards, while the control is the power to withdraw the electricity supply, water supply, etc. For the legal regime, firstly, it establishes pollution control boards. Secondly, it sets up standards specifying permissible levels of pollution. And thirdly, it provides penal provisions to ensure compliance. The main object is maintaining the wholesomeness of water bodies. The preamble to the Act talks about the objectives, namely maintenance and restoration of water pollution, establishing boards to prevent and control water pollution, and assigning functions to the boards and conferring them with powers to meet the objectives of the Act. Pollution is defined in Section 2, Clause E. Now, the Act defines pollution to include each and every act which is or is likely to prove injurious to health of any living organism. The Act also creates three authorities, namely the Central Pollution Control Board under Section 3 at the center, the State Pollution Control Board under Section 4 for individual states, and joint boards under Section 13. To avoid some sort of a conflict between states in the case of formation of joint boards, the Act gives power to the central government to give directions in relation to the matters which fall within the territorial jurisdiction of two or more states or union territories. The CPCB is to act in line with the directions given by the union government. And the directions of the CPCB or the state government will bind the State Pollution Control Board, SPCB. However, where there is an inconsistency between the directions given by either the state government or the CPCB, the matters refer to the central government for clarification under Section 18. The CPCB shall promote cleanliness of streams and wells in different areas of the state. It has some duties as well. For example, advising the union government on matters relating to protection of water from being polluted, coordinating the activities of various state boards by resolving their disputes, providing all possible kind of assistance to them in performing their functions, organizing all possible kind of programs to promote cleanliness of water bodies, dissemination of information connected with achieving the objectives which are laid down in the Act, and more importantly, laying down the emission standards from various sources, which is mentioned under Section 60. The State Pollution Control Board also has certain duties. It has to plan a comprehensive program for the prevention, control, and abatement of pollution of streams and wells in the state. The SPCB also advises the state government on matters related to cleanliness of water, collection and dissemination of information relating to water as well. The SPCBs, they are also supposed to work in collaboration with the central board and have to regularly inspect the sewage or trade effluents which are emitted from different sources. The SPCB is also to inspect plants and other treatment methods which are used to treat the sewage and trade effluents. The board also should lay down and modify effluent standards for sewage and trade effluents and for the quality of receiving waters. It also has the duty to evolve economical as well as reliable methods for the treatment and disposal as well as better utilization of sewage and trade effluents. The board is also supposed to lay down standards as to the emission of trade effluents. And that apart, it also has to take all necessary steps to make, vary, or evoke any order which has been passed under the Act. This power has been given under Section 70. Apart from this, there are quite a number of other powers which have been cast on the authorities created under the scheme. The power to obtain information. State boards have the power to enter and survey any area in order to ensure that the law is being complied. They can also give directions to any person in charge to furnish information related to construction, installation, or operation. The boards also have the power to take samples of effluents. Certain standards for emission or discharge of environmental pollutants from the industries, operations, or processes are laid down by EPA rules. To examine the compliance of these standards, the pollution control boards can collect samples of water from any stream or well or any sewage or trade effluents and send it to be analyzed by certain authorities which are authorized under the Act. A detailed procedure for taking samples and sending it for analysis is laid down under Section 21. For the person who collects the sample, he should serve on the person in charge a notice as to his intention of collecting of effluents for analysis. The sample should then be collected in the presence of such occupier or his authorized agent. Now, once these samples are collected, the officer who has collected should divide these into two parts, cause it to be placed in a container which should be marked and sealed and should be signed both by the officer as well as the occupier or his agent who is being duly authorized. Now, out of these two containers, one should be sent to the lab established or recognized by the boards, and the other, on the request of the occupier or his agent, shall be sent to a lab established by the government. Now, the reports of the samples so analyzed shall be made in triplicate and shall be sent to the central board or the state. After receiving this report, the board should send one copy of the report to the occupier or his agent and should retain the remaining two copies with itself. One to be used for its own purpose and the other should be made available as evidence before court in case of initiation of any legal proceeding. If the report of the sample analysis done by the government analyst is inconsistent with that of the analysis done by the lab established or recognized by the central board or the state board, then the report of the latter shall prevail. You also do have the power of entry and inspection. Any person who is authorized by the board has the power to enter any place at any reasonable time in order to perform the functions which are assigned to him by the board, to determine whether and in what manner the various requirements under the Act is being carried out or not, to examine any plant, record, register, document or any other material object, or for conducting a search of any place. The power to refuse or withdraw consent is another thing that has to be noted. The state board can refuse to grant a consent order for establishment or to alter outlet if it is of the opinion that the person applied for such consent order is not in a position to comply with the condition imposed by the board. The board can also review from time to time any condition imposed while granting consent and can make reasonable variation or revocation of any such condition at any point of time. The board also has the power to carry out certain works. For example, where any person who is required under the Act to carry out a work fails to execute it, then the board has the power to serve him a notice requiring him to carry out the work in a reasonable time specified in the notice and to get the work done. If such person fails to execute the work within the time specified in the notice, then the board itself can carry out the work on its behalf and collect expenses incurred for it from him. The board also has the power to take certain measures in emergency situations. If the state board apprehends that due to any accident, unforeseen act or event, any poisonous, noxious pollutant is present in any stream, well or land, and it is very much necessary to take immediate action to prevent any further danger, then the board can take all such immediate measures as is necessary for removal of such danger. However, in exercise of this power, the board cannot construct any work which is permanent in nature. The board also has the power to move the court, seeking an order to restrain any person who, in the opinion of the board, is polluting or is likely to pollute the water in any stream or well. The board also has the power to give directions. Now, the state board can order directions to any person, officer, or authority, including orders to close, prohibit, or regulate any industry, operation, or process, and to stop or regulate the supply of water, electricity, or any other service. The consent order under section 25 lays down that every person intending to establish or take any steps to establish any industry, operation, or process, or any treatment and disposal system, or any extension thereto, which is likely to discharge sewage or trade effluent, shall take previous consent from the state board. Now, once this application is received by the state board may, after such inquiry as it deemed fit, pass an order, either refusing to grant consent or grant consent unconditionally or subject to certain conditions. Where a person, without getting a consent order from the PCB, undertakes any act, then the state board may serve on such person a notice imposing any such conditions as it might have imposed on an application for its consent. Where the board receives an application for grant of consent, it shall respond to the application within 4 months of the receipt, according to section 25, subclause 7. The consent for emission is deemed to have been given unconditionally on the expiry of the said 4 months. Section 49 allowed citizens to bring actions under the Water Act. Courts can take cognizance of offences only when a complaint is made by either a board or by a person who has given 60 days notice of his intention to make the complaint. Where a notice has been given by any person, the board shall, on demand by such person, make available relevant reports in its possession to that particular person. However, the board may also refuse to make any such report available to such person if the same is, in its opinion, against public interest. Failure to comply with directions given under various sections of the Act lead to varying kinds of punishments as prescribed in the Act itself. The next important legislation is the Air Prevention and Control of Pollution Act of 1981. Now, the basic framework is the same as that of the Water Act. Section 2B of the Act defines air pollution as the presence in the atmosphere of any air pollutant. Air pollutant is defined under Section 2A. The term emission under the Act is defined as to mean any solid or liquid or gaseous substance coming out of any chimney, dust or flue or any other outlets. Sections 3 and 4 of the Act states that the CPCB and the SPCB under the Water Act shall act as CPCB and SPCB for the Air Act as well. This prevents multiplicity of boards and members related to prevention and control of pollution. Similar powers also do exist under this Act as well. Each state government can designate particular areas as air pollution control areas after consultation with the state board under Section 19. Now, in such designated areas or declared areas, the state government under the Act can even prohibit the use of any material or fuel if it is of the opinion that this is likely to cause air pollution. The state government, on consultation with state board, can also give instructions as it deems fit to concerned authorities in charge of registration of motor vehicles, and he shall be bound by the direction so given by the authority. Every person intending to establish or operate any industrial plant in an air pollution control area shall obtain consent from the state government. The state board also has the discretionary power under the Act to either grant or refuse to grant permission. Under Section 24, power of entry and inspection is given to the board in order to enable them to perform some of these important functions. Under Section 26, the board has the power to take samples of air or emission in order to analyze it, to testify as to whether the samples are in compliance with the consent that has been given by it. However, any deviation from the procedure will make the analysis report inadmissible as evidence. Under Section 31 capital A, the board has the power to issue directions to any person, officer or authority. If they fail to comply with these directions, the board can specifically direct 1. The closure, prohibition or regulation of any industry, operation or process, or 2. The stoppage or regulation of supply of electricity, water or any other services. Apart from these pollution control laws, you also do have to look into certain other laws that are there in India related to environment, forests, wildlife and biodiversity. We'll have an overview of the laws related to environment, forests, wildlife and biodiversity in India. The Environment Protection Act of 1986 helps implement decisions which have been taken at the Stockholm Conference. What it does is, it takes all necessary steps for the protection and improvement of human environment and also helps to prevent hazards to human beings, other living creatures, plant as well as property. The word environment has been defined as which includes water, air and land, and the interrelationship which exists among and between all these three and human beings, other living creatures, plants, microorganisms and property. Now, under this Act, the central government is also handed with certain powers. The central government is supposed to act as some sort of a nodal agency and is to coordinate actions taken by the state government officers and other authorities under the Environment Protection Act or under the Environment Protection Rules. The central government is also supposed to plan and execute a nationwide program for the prevention, control and abatement of environmental pollution. It is also supposed to lay down standards for the quality of the environment. It is also supposed to lay down standards for emission or discharge of environmental pollutants from various sources. It also has the duty to restrict areas in which any industries or operations or processes shall be carried out. It also should lay down procedures and safeguards for the prevention of accidents that are likely to cause environmental pollution, and also lay down procedures and safeguards for handling hazardous substances. Section 3.3 authorizes the central government to constitute one or more authorities to implement this particular act. Under Section 5 of the Act, the central government, it has this tremendous power of issuing directions to any person, officer or any authority to close, prohibit or regulate any industry, operation or progress, or to stop or regulate the supply of electricity or water or any other services. Under sections 3 and 5, the central government has all such powers as are necessary and expedient for the purpose of protecting and improving the quality of the environment. By virtue of this power, the central government has passed various rules on the matters related to environment, biodiversity, noise, hazardous wastes, etc. The central government has the power to enter any place under Section 10 of the Act. Under Section 11, the central government or any officer empowered by the central government can take samples of air, water, soil or any substance from any factory, premises or other place for the purpose of analysis. A set procedure need be complied with by the person who is taking the sample, and only then would it be treated as evidence before a court of law. By virtue of Section 15, if a person fails to comply with or contravenes any of these provisions that are laid down in the Act, or the rules or the orders or directions, such person shall be punishable with imprisonment for a term which may extend up to 5 years, or with fine which may extend up to rupees 1 lakh, or with both. In spite of the punishment, if the failure or contravention still continues, then the person will be imposed an additional fine which may extend to rupees 5,000 per day of contravention. If the failure or contravention continues beyond a period of 1 year after the date of conviction, then the offender shall be punishable with the imprisonment of a term which may extend to 7 years. If a company has committed any offence, then every person who was directly in charge of the company for the conduct of the business shall be deemed to be guilty of the offence and will be liable to be punished accordingly. If any offence under this Act has been committed by any department of the government, then the head of the department is deemed guilty of the offence and he shall be punished accordingly. Now, the Environment Protection Act also provided the citizen the right to move the court complaining of an offence under the Act. The next one is the Indian Forest Act of 1927. Now, this is an act which evolved during the British rule. It aimed at consolidating the laws that exist in relation to the forests, transit of forest produce, and the duties which can be levied on the forest produce and timber. The Act defines forest produce, procedures involved in the declaration of forests as reserved forests, protected forests and village forests, the acts of prohibition, the authorities that are involved in the conservation and protection of the forest land, their role, and the procedures which are involved, as well as the penalties in case there is any contravention of the provisions of the Act. This Act provides for 3 authorities: central government, the state government, and the Forest Settlement Office. You also do have some sort of a classification of forests under the Act. Reserve forests mentioned under Section 27, wherein the state government has the power to declare a reserve forest. Protected forests, which is to be done by the state government by way of a notification in an official gazette. And village forests, The state government has been, under the Act, entrusted with the task of assigning to any village the rights over any land that comes under the reserve forest area. These forests that are assigned to a village are referred to as a village forest. You also do have the Forest Conservation Act of 1980, the main objectives of which are imposition of restrictions on dereservation of forests, restriction on the use of forest land for non-forest purpose, conservation of forest wealth, check further reforestation, and maintenance of ecological balance. There are a number of authorities that are present under this Act. The central government has the power to regulate the activities in the forests and also restrict activities of the state government and other concerned authorities. It also constitutes an advisory committee. The state government also has functions laid down but are supposed to seek prior approval to the central government for following activities: dereservation of reserve forests, use of forest land for non-forest purposes, assignment of lease of any forest land to a private person or an authority or a corporation or an agency, cutting of naturally grown trees in any forest land which are grown for the purpose of reforestation. The Act also lays certain restrictions on the diversion of the use of forests from forest to non-forest purpose, taking into account the interest of the nation as a whole. This requires prior approval of the central government. One of those next acts which assumes significance is the Forest Rights Act of 2006, which lays down the rights of forest dwellers. Now, this was enacted as a result of the international steps that were taken to protect such rights, and it aimed to protect and preserve the rights of tribals. It also ensured that their cultural identity and traditions would be protected. The Act aims to ensure that forest-dependent people improve their economy. The Act recognizes and vests forest rights in the forest-dwelling scheduled tribes and other traditional forest dwellers on all forest lands, including sanctuaries and national parks. The Act also aims to correct the historical injustice that has been meted out to the forest dwellers. And the importance of this Act is this is the first time that such a historical injustice has been acknowledged. The Act does have quite a large number of salient features. It recognizes forest rights. It does confer rights in national parks and sanctuaries, which it has renamed as critical wildlife habitat. It recognizes the right of ownership and access to collect, use and dispose minor forest produce. It recognizes the right to in situ rehabilitation. It also mentions that no member of a forest-dwelling scheduled tribe or other traditional forest dwellers shall be evicted or removed from forest land under his occupation till the recognition and verification process is over. Gram Sabhas were also given rights as well as duties to ensure proper implementation of this right. The Act also lays down certain duties which are to be followed by the right holders: protecting wildlife, forests and biodiversity, protecting water sources in the area, protecting habitat of traditional right holders, and it should also ensure that Gram Sabha decisions are followed. The Wildlife Protection Act of 1972 is yet another legislation. This is one of the earliest legislations which have been enacted to protect wildlife. It has an elaborate definition as to what comes under the term wildlife. It aims at protecting the components of biological diversity and maintaining the ecology and environmental security of the country as a whole. The main objectives include maintenance of ecological balance, conservation and protection of flora and fauna of the protected areas, regulation of the hunting of wild animals and birds, regulation of possession, acquisition or transfer or trade in wild animals, articles and trophies, constitution of authorities to achieve the objectives of this particular act, and protection of the wildlife by creating sanctuaries, national parks and closed areas. There are a number of authorities which have been created on the act. They include the director, who's been appointed by the central government, the chief wildlife warden, wildlife wardens and honorary wildlife wardens, the National Wildlife Board, which has been established by the central government, Standing Committee of the Board, the State Wildlife Board established by the central government, and the Central Zoo Authority. Now, this act was also amended in the year 2002 and aimed at ensuring better protection and conservation. Now, under this, the state government could declare any area as a sanctuary or a national park. The permission of the Chief Wildlife Warden is required to undertake activities in the sanctuary. And this permit shall not be granted unless the state government consults the Wildlife Board in this regard and is satisfied that the activities are for the improvement and the better management of wildlife. The state government is also empowered to declare adjacent areas of the national park or a sanctuary owned by the government as a conservation reserve with consultation with the local communities. The state governments shall then constitute a committee, which is called a Conservation Reserve Management Committee, which shall act as an advisory to the Chief Wildlife Warden and advise him on quite a large number of matters. By virtue of Section 5 capital A, a national board is created with the Prime Minister as the chairperson, the Minister in charge of forests and wildlife as the vice chairperson, and the Director of the Wildlife Preservation as the member secretary of the board. Now, this board has a number of duties, including framing policies, advising the central government on matters related to wildlife protection, recommend setting up and managing national parks, sanctuaries, and other protected areas, conduct impact assessments, and to prepare some sort of a status report of wildlife. The state government can also constitute a state board for wildlife, which provides advice to the state government on matters related to declaration of specific areas and formulation of policies. You also do have a Central Zoo Authority, which is created to look after the management of zoological parks in the country. And it also coordinates and supervises the exchange of animals on a scientific basis. The Chief Wildlife Warden is the authority solely responsible for the control, management, and maintenance of the sanctuaries. Another act which assumes significance is the Biological Diversity Act 2002 and rules. Now, India was a signatory to the CBD, and the Biological Diversity Act was enacted to achieve the objectives that were laid down in the CBD, the Convention on Biological Diversity. Now, the BDA, it aims to protect India's rich biodiversity and associated knowledge from being used by foreign individuals and organizations without sharing of benefits arising out of such use. It also aims to conserve and promote sustainable use and equitable sharing of benefits of India's biodiversity resources. It also says that promotion at all levels of a good documentation of biological diversity, its uses and associated knowledge is also to be done. It also helps in developing a well-designed biodiversity information system for India to serve as something akin to a knowledge base. It also aims to check biopiracy. Now, for all these aspects, they have established a three-tier management system: a National Biodiversity Authority, state-level biodiversity boards, and local-level biodiversity management committees. To this effect, it creates the NBA, the SBA, and the Biodiversity Management Committee, the BMC. Now, the National Biodiversity Authority, it helps in regulating access to biological diversity by both national and international individuals and entities, and issues guidelines in this regard. It also helps in controlling access to genetic resources by international community. The NBA also provides approvals for transferring results of research with respect to any biological resources to foreign nationals or organizations. It advises the central government, and a prior approval of the NBA is required for securing intellectual property rights. The authority would also grant the approval after imposing a benefit sharing fee or royalty or any other precondition as it may consider appropriate. The authority also decides the benefit sharing arrangements. It also decides on joint research projects in collaboration with foreign universities. The State Biodiversity Board also has similar functions and roles. It controls access to genetic resources, advises the state government, grants approval for commercial utilization, and it also mentions any commercial utilization of the biodiversity has to be intimated to the State Biodiversity Board. And the SBBs, they have the power to prohibit or restrict any activity that it thinks is against the objectives which have been laid down on the Act. The Biodiversity Management Committee, the BMC, are created by the local bodies within their area of jurisdiction. Now, both the SBBs and the NBA has to consult the BMC if it deals with biological resources within the BMC's jurisdiction. And the BMC can levy fees for such use. It has to submit a copy of its annual report and accounts at the end of every financial year to the concerned local body. Now, this gives a brief description about what environmental laws in India are. It is also necessary that we look at some of those steps that have been taken internationally as well. The United Nations Conference on Human Environment, Stockholm, 1972, was the first time that an all-inclusive approach as regards environment protection was taken. Now, this was enacted to provide for a common outlook and for common principles which aimed at inspiring and guiding the people of the world, and also to help conserve, preserve, and enhance the human environment. CITES is yet another international step that has been taken to protect and ensure that international trade will not result in harm being caused to flora as well as fauna. Now, CITES, it has 3 appendices. The first includes all species that are threatened with extinction, which are or may be affected by trade. Trade has strict regulations and can be authorized only in exceptional licensed circumstances. Appendix 2 includes all species which, although not necessarily now threatened with extinction, may become so unless their trade is subject to strict regulation. Appendix 3 includes all species which any party identifies as being subject to regulation within their jurisdiction for the purpose of preventing or restricting exploitation, and as needing the cooperation of other parties in the control of trade. You also do have the Ramsar Convention of 1982, which aims at protecting wetlands and is an intergovernmental treaty which asks members to maintain the ecological character of the wetlands of international importance. Now, the convention, it plans for wise use or sustainable use of wetlands, and it comes up with a legal framework for national action and international cooperation. Wise use is defined as the maintenance of their ecological character, achieved through the implementation of ecosystem approaches within the context of sustainable development. Now, wise use, therefore, has at its heart the conservation and sustainable use of wetlands and their resources for the benefit of mankind. The World Commission on Environment and Development aimed at a global agenda for change and was set up by the United Nations General Assembly in 1983 with Brundtland as the chairperson. You also did have the United Nations Convention on Environment and Development, 1992, which was also called the Rio Conference and which paved the way for sustainable development. Agenda 21, which was a part of this, was a plan of action which was formulated to that effect. This lays down strategies and plans of action that can be followed to lessen harm caused to the environment. You also did have the United Nations Framework Convention on Climate Change, which mandated that national policies need be made to to mitigate the effects of climate change, and the ultimate aim was reduction of greenhouse gases. Another important step that was taken is the Convention on Biological Diversity, 1992. The three most important objectives of this convention are conservation of biological diversity, sustainable use of its components, and the equitable sharing of benefits arising from the utilization of genetic resources. You also did have the Cartagena Protocol on Biosafety 2000, which regulates international trade in GMOs and safety of LMOs as far as its handling and transfer are concerned. The Nagoya Protocol on Access and Benefit Sharing, ABS, to the Convention on Biological Diversity 2010 provides a transparent legal framework for the effective implementation of one of the three objectives of the CBD, fair and equitable sharing of benefits. That apart, you also did have the World Summit on Sustainable Development 2002. The two main outcomes were a WSSD plan of implementation and Johannesburg Declaration on Sustainable Development. That apart, you also did have the Rio Plus 20 Summit in 2012. Now, member states decided to launch a process to develop a set of Sustainable Development Goals, SDGs, which will build upon the Millennium Development Goals and converge it with the 2015 Development Agenda. Now, it mainly focused on two themes: a green economy in the context of sustainable development and poverty eradication. This laid down the institutional framework for sustainable development. The growth of environmental law as a subject has been able to capture the minds of people from various parts of the globe, from various backgrounds alike, and this can be said to be the plus point as regards this line of jurisprudence. As far as the growth and future of environmental law as a subject is concerned, there have been quite a number of developments that are taking place. It is understood that there need be a subtle change of approach as far as environmental law is concerned. What has prevailing till date has been considered to be an anthropocentric approach. The concerns of man and mankind have been given preference over the rest, and the time has come to change it. There have been quite a number of developments taking place all over the world, where the idea as regards an ecocentric law has been broached. This has been in the offing by the United Nations as well, which has come up with the Harmony with Nature initiative, which aims at providing some sort of a legal backing to such ecocentric approaches. Let us hope that such initiatives help in ensuring that we, humans, realize our role and responsibility in protecting the environment for its own sake and not for our own sake.